Welcome. Thanks so much for joining us for this conversation. I can tell by the rapidly increasing numbers that there's a huge amount of interest in what happened yesterday at the Supreme Court, what this means for human rights litigation in the United States. I'm really excited about the panel that we've put together today. This is a particularly distinguished group of people that is going to have a lot of comments I'm sure that we're going to be excited to hear about. So let me do quick introductions. I didn't run these bios by each of these folks, so y'all can correct these if you want to, if you need to. So Paul Hoffman, I'm sure most of you know who Paul Hoffman is. He's a partner at Schonbrun Seplow Harris Hoffman and Zeldez, where he specializes in constitutional and civil rights litigation, human rights, and civil and criminal appeals. Yesterday was, I believe, his fourth argument. Is that right, before the Supreme Court? Seventh? Oh, excuse me. Yesterday was his seventh oral argument before the Supreme Court, having previously argued the landmark Sosa v. Alvarez and Chain and Kiobel v. Royal Dutch Petroleum cases, as well as several others. And he is often considered to be the leading alien tort statute litigator in the United States. Terry Collingsworth is the executive director and founder of International Rights Advocates and the former executive director of the International Labor Rights Forum. He has filed about 11 cases against U.S. corporations for human rights abuses overseas, including against Chiquita and Dole and Coca-Cola, Exxon, Occidental Petroleum, Drummond Coal, and others. And Terry and Paul are both counsel for the bill plaintiffs. Beth Van Schaack is the Lee Kaplan Visiting Professor in Human Rights at Stanford Law School and a faculty affiliate with Stanford's Center for Human Rights and International Justice. She was previously the deputy to the Ambassador at Large for War Crimes Issues in the Office of Global Criminal Justice of the U.S. Department of State, and she co-authored one of the amicus briefs in this case, the Brief of International Law Scholars, former diplomats, and practitioners. Shawn Askinosie is the founder and CEO of Askinosie Chocolate, a small batch chocolate manufacturer in Springfield, Missouri. Shawn is the author of Meaningful Work, The Quest to Do Great Business, Find Your Calling, and Feed Your Soul. And he was named by Oprah's magazine as one of 15 guys who are saving the world. Askinosie is one of 18 companies that filed an amicus brief in this case on behalf of small and mid-sized chocolate and cocoa companies. And last, but certainly not least, we have Diana Kearney. She's the Legal and Shareholder Advocacy Advisor at Oxfam America. Her work focuses on corporate accountability, indigenous land rights, migrant protections, and other international human rights issues in support of Oxfam's humanitarian work. Oxfam joined an amicus brief in this case written by economics professors Joseph Stiglitz and Jeffrey Heel. So I see that we have even many more participants. So welcome to everyone who's joined us. My name is Charity Ryerson. I'm the Executive Director of Corporate Accountability Lab. I'm going to throw some questions out to each of our panelists to have a discussion amongst ourselves, and then there will be time, you can hear someone shuffling around. So maybe everyone who's not speaking, if we can mute when we're not speaking. So, at the end, we'll have some time for questions, given that we're doing this in webinar mode. If folks want to start putting questions into the Q&A, there's a chat function, but there's also a Q&A. So if you could use the Q&A and you can start putting your questions in as we go. And toward the end, we'll have a little bit of time to hit those. When you do put in your questions, if you could also identify any organizational affiliation you may have, and I will read out your name and affiliation when I ask your question. So I'd like to start with Terry. So Terry, you have been working in the cocoa sector in West Africa for many, many years. You filed this case back in 2005. Just for folks who, I think a lot of folks are familiar with this case, but just as a reminder, who are these plaintiffs? What is the situation in West African cocoa? Why did you file this case?
Yes, I actually spoke to one of them to give him an update, John Doe 1. The kind of the sad story part of this is that they are now all about 30 years old. When we filed this in 2005, 15 years ago, they had recently been freed as child slaves. And I want to, our complaint and the Supreme Court brief touch on this some, but the one issue that needs to be emphasized throughout all of the abstract discussions about whether corporations can be sued, what is the standard of liability, et cetera. These kids were kidnapped from Mali, where they lived. They were kidnapped by false pretenses. This is very common and it still goes on today. They were told they would get a good job harvesting cocoa. They'd be paid and all the conditions would be fine and so on. So they all were taken from Mali to Cote d'Ivoire. They were taken to cocoa farms in the middle of nowhere where they speak a different language. They did not have one penny in their pockets, and they were told to work or starve. Now, back in those days, the conditions were worse than they are today for the child slaves, but child slavery is more commonplace. There's more slaves today than there were then because the industry is expanding. But back in the early days, they were imprisoned. They were locked up at night. They were guarded. If they tried to escape, they were severely punished. John Doe 3, for example, tried to get away, and when they caught him, they slashed the bottom of his feet with a machete and rubbed chilies in it. And he still has those scars. And all of the guys, all 6 of them, have scars on their back from being whipped. They were whipped like slaves in the movies. It's just unbelievable how they were treated. Today, as I said, there are more slaves, but at the same time, I think that just the desperation that causes kids to hop in the van when they're told a good job is waiting for them, that the abusers of these children realize they don't have to beat them or lock them up. They take them to the middle of nowhere. They don't have any idea where they are. They don't have any money, and they basically still say work or starve. And we're about to bring a new case under the Trafficking Victims Protection Act, and we have 9 new plaintiffs that I met last year. They were all trafficked in the same way, but they were never guarded like this. And it took each of them, it's hard to believe, but it took each of them about 3 years to figure out how to get out of there. And that's pretty common. They get stolen when they're about 12. And then when they're about 15, they're getting into mid-adolescence and they're, developing, they're big guys now. And then they finally say, I don't care if I'm going to starve to death. I'm going to walk my way out of here. And they do. Somehow they get home. Some of them don't. But the stories are all horrible of begging for food, stopping in cities, trying to get odd jobs. And all they want to do is get back home because they were never paid. It was always a lie. And as most of you know, the NORC report came out about a month ago, said there are 1.6 million kids working today. Now, most of those weren't trafficked, but the conditions are still horrible for them. I'm working with a film crew. Mickey Mastrati is making another film about the child labor in cocoa. And he filmed us with kids working. But I picked up a machete one day, and the kid showed me how to open up some cocoa pods and showed me how to clean around the trees. And it was about 100 degrees Fahrenheit that day. And I had bottles of water that were clean, but I worked for about 15 minutes and I was a sweaty mess and I was tired. And these kids are doing that for 9 or 10 hours a day, drinking filthy water and eating rice. It's just horrible what these companies are getting away with. I'll stop there, or I can rant forever.
Thanks, Terry. That was really helpful. I mean, there's a lot at stake in this case, so that was really helpful context to kind of understand why, why is this winding up here in the U.S. in court? And maybe that kicks us over to Paul. So, Paul, you were in the hot seat yesterday, arguing before the Supreme Court. There was a lot of issues that the justices picked up on in the argument. I wonder if you could just highlight a few of them. What did you think they were most interested in, and what do we think are the thorniest issues in this case?
Okay, thank you. I think it is important to remember the factual context, and I think that it's important I think that the justice's response to the case has a lot to do with that context. Not that much was said about it in the argument, but I think that the fact that this has to do with child slavery and forced labor was an important background fact for all of them, probably, and a reluctance to accept the corporation's arguments. The 2 main issues that were before the court is whether the Alien Tort Statute, which is the statute that we have used for the last 40 years to enforce human rights in U.S. courts, applied to any actions by corporations outside U.S. territory, and whether it applied to corporations at all. And the corporations took very broad views on eliminating all of these kinds of cases. And if accepted, the arguments would have basically gutted the Alien Tort Statute, and they were joined in that by the Trump administration, which changed some of its positions in this case. And I think one of the most encouraging things about the argument is that it didn't seem that any of the justices had much of a stomach for giving complete corporate immunity. They just didn't seem to be buying that argument. And the other thing that was encouraging is that they didn't seem to be buying the argument that the Alien Tort Statute was limited to violations on US territory, that it couldn't be used to police US corporations when they engage in serious human rights violations outside the country. They didn't say that in so many words, I think, but my overall impression of the argument is that there really wasn't all that much interest by any of the justices in buying the particular arguments that the corporations were making to gut the statute. I think the other thing is that what we always worry about in the Supreme Court when the Alien Tort Statute gets there is that there might be some argument from the justices to basically end the ability to use the Alien Tort Statute for this purpose. That's been true in Sosa and Kiobel, all the cases. It didn't seem like any of the justices were making an argument that the Alien Tort Statute could never be used or that they should overturn their decision in Sosa versus Alvarez-Machain. In fact, it seemed that even Chief Justice Roberts, who wrote the Kiobel opinion, was open to the idea that policing US corporations is a different question than imposing US jurisdiction on what foreign corporations do outside the United States, which was a central part of our argument. And I didn't think that the corporations got much traction against that. I think that what did come across was that some of the justices, particularly the more conservative ones, have questions, some skepticism about what their role should be in applying the Alien Tort Statute, which derives from 1789, in modern times. Sosa was the first attempt by the court to basically give a modern interpretation to the statute, but some of the conservatives are still skeptical about what their role should be. And I think that's a debate that, you know, they'll decide that in some way in this case. And there'll be a fight within the court about how broadly to interpret the Alien Tort Statute. But I didn't get a sense that they were about to overrule Sosa or end this process altogether, which I think is good news. A lot of the questions came up in the context of our particular allegations and our complaint and whether aiding and abetting is appropriate and as a theory of liability. So, I mean, the basic issue is what is it that a US corporation has to do to be found liable when they're connected to violations like the ones that Terry has there. And that was not technically in front of the court. It's not clear what they're going to do with that. I think that's going to be a continuing debate in Alien Tort Statute litigation in this case and in other cases. And it's not clear where they'll come out on that. But I think, and Beth will say more about her brief on these issues. I think we still have pretty good arguments about the fact that this liability is available under the Alien Tort Statute. And if we had full briefing on that, I think we could convince a majority of the court that, at least in some circumstances, aiding and abetting liability for corporations is appropriate. So I'm hopeful. I think the argument went as well as we could have expected. I know that it's hard to listen to it and understand that in terms of the intricacies of it, because sometimes it sounds different from what the real issues are in the case. But I think for those of us that have been deeply immersed in it, we came out of the argument yesterday feeling pretty good about it.
Great, thanks, Paul. I mean, just to sort of echo that, the questions for Neil Katyal, I mean, he was really on the hot seat. I felt like he had a pretty hard, he had a lot of really tough questions, and so that was comforting. But this is a natural kind of transition to Beth here to speak a little bit about aiding and abetting liability. So the amicus brief that you submitted, Beth, was on this issue. One thing that came up in the argument yesterday was Justice Sotomayor came up with a hypothetical. I think she said that it boggles the mind, or she said something really sort of like that about the idea that if somebody aided and abetted piracy, that's because this statute has often been used or thought to historically have been created around piracy, rather, that aiding and abetting piracy from land or from sea would make a difference, that you would need to aid and abet it from the sea under this theory, even though they're saying there's no aiding and abetting liability at all. So I would be interested to hear your thoughts on aiding and abetting liability in general, and then how this sort of overlaps with the issue of extraterritoriality in Sotomayor's question and otherwise.
Sure. Yeah. Thanks so much. Hi, everyone. It's great to be here. And thanks so much for the background on the case, which it's really important we do not lose sight of as we start dancing on these the heads of these jurisprudential pins. This is about children who are enslaved so that we can have hot chocolate in cold weather. So we just need to remember that, and we need to support small, artisanal, fair trade chocolate companies when we're doing our purchasing power, when we're using our purchasing power. So as has been mentioned, this case really does hinge on a kind of complicity or secondary liability theory. The argument is that it's the farmers, the producers, the plantations in West Africa that are engaged in the actual acts of trafficking and enslavement, but the corporations are facilitating that. They're profiting from it, they're providing oversight, they're providing training, and they are well aware that child slavery and other forms of forced labor have infected their entire supply chain coming out of West Africa. And so that's the theory of responsibility. Now, neither of the parties, neither of the two defendants tried to raise this question in their petitions for the court to hear this case. They focused on the extraterritoriality issue, as we've discussed, and also the broader question of whether US corporations can be sued under this Alien Tort Statute. And it's not surprising in a way that the two defendants would not try and contest the cognizability of aiding and abetting liability and other forms of secondary liability under the Alien Tort Statute. Why? Well, because every court that has reached the question has either assumed or has ruled directly that, of course, if you can sue the direct perpetrator, why should we not be able to sue someone who assists, knowingly providing some sort of assistance to behavior that violates the law of nations? It doesn't make sense to imagine a statute that would only allow for suits against the direct perpetrator, unless Congress is very specific in saying that. And so neither of the defendants raised this. It was the government, the Trump administration, that tried to inject this issue into the litigation. Both at the stage at which they were asking for the court to take the case, and then when they were asked to brief on the merits. And so the issue was there, and I think Paul quite brilliantly realized that there was some possibility that the justices would take this up. And so we ended up doing a brief, essentially making the argument that aiding and abetting liability is very well established under all forms of international law. Under comparative law, almost every legal system in the world has forms of complicity liability. Every international tribunal that asserts jurisdiction over violations of the laws of nations has included provisions allowing for complicity claims to be brought. Every circuit court that has looked at this issue has agreed and has cited all of this litigation in order to identify what the relevant standards are. And so our brief tried to start back in the time of history and say, of course, the first Congress, the framers, our founding fathers, would have assumed that they inherited this doctrine from England, and they would have assumed that the Alien Tort Statute would support such claims. And we cited a number of historical examples, some arising out of piracy and other sorts of events, including an interesting case involving Sierra Leone, where US citizens were involved in enslavement and were also assisting the French. And so there were questions about whether or not they could be held liable under the Alien Tort Statute. A case never formed, but there was an authoritative decision issued that said, of course, anyone who aids and abets a violation of the law of nations could potentially be liable under this Alien Tort Statute. So our brief tried to bring together this historical background relying on international law as it existed at the time, and then bring the justices forward to the contemporary era. Now, as you mentioned, Justice Sotomayor very clearly had read our brief. I'm deeply honored, as you can imagine. She has really proven herself to be quite adept at understanding international law. We saw this in the earlier Jessner case as well. She's clearly quite interested in international law. She sees it as part of her role to apply it to situations that come before her, because international law is, in essence, part of United States law. We're bound by that, as are all other nations of the world. And so she was really playing with some of these ideas that how could you possibly make the argument that only if piracy, an act of assistance happened here in the United States, would that be cognizable, when the whole notion of piracy is that it happens on the high seas. And so why should it only be extraterritorial? Why should we not have cognizance over acts of assistance that are extraterritorial and only on US soil? We had other questions from other justices about just the incongruity of allowing for suits against the individual perpetrators, but not against those who might provide ultimately essential assistance to those perpetrators. And so even though this question of aiding and abetting was not directly presented or in the questions raised by the court, it I think was quite crucial that the justices understood that this is a very standard form of liability. There are standards that can be identified under international law and applied by US courts. And frankly, they've been doing this since these cases began.
Great, thanks, Beth. That was really helpful. I hope that we have a little bit more opportunity. There was such rich discussion during the argument to talk about aiding and abetting. There's probably more things we can touch on maybe during the Q&A. But I want to jump over to Shawn. So Shawn, you run this chocolate company. You joined 17 other companies in a brief on behalf, for these trafficked children, saying there should be corporate liability in a case like this. Now, I think, folks might have seen that amici on the other side, including Coca-Cola, business interests are going to oppose corporate liability in cases like this across the board. So why would you and 17 other companies take this position?
First of all, thank you for the invitation, and it's an honor to be with these other panelists, and a special thank you to Paul for your work. I listened to the oral arguments yesterday, and having been a criminal defense lawyer for 20 years, and while I haven't argued a case in the Supreme Court, I've been in the hot seat, and so bless you, sir, for your work. So why are we a part of this? Well, after I left my criminal law career, I started this little company, 17 people in my business. I run it with my daughter. And it's possible to do things the other way. It's possible to make chocolate without slaves. This year, I would have taken my 46th origin trip since I started the company 14 years ago. I always go visit the farmers in Tanzania, Ecuador, Amazon, and the Philippines every year to look at the beans before we buy them, and also to profit share with the farmers. We open our books to them. We translate our financial statements into their language so they can see how we calculate the profit share. And guess what? We're profitable. We make money. We're not billionaires, but we love the work that we do. And we wish that this landscape, this world global landscape in the chocolate industry was fair. We wish that it was a level playing field. But guess what? If you use slaves to make your chocolate, then the bar is going to be cheap. It's why the bar at the convenience store counter is $2, or when you go to the large big box store and you can buy a bar for $3 or $4. The reason why you can do that is because it's made by slaves, by child slaves, or by slaves. And so it shouldn't come as a shock to consumers that when a company like mine, for example, if we charge $8 or $10 for a chocolate bar, it's a value. It really is a value. And in fact, the $1 chocolate bar is what's the ripoff. And so we're hopeful that this litigation and litigation that follows, and hopefully other legislation, will create mechanisms by which these defendants and named bad actors in the litigation, say, for example, Barry Callebaut, the largest chocolate maker in the world, cannot sell their products in the United States if they can't prove that it wasn't made by slaves. So anybody who has their chocolate made by Barry Callebaut, and there are plenty of them, Tony's, for example, shouldn't be able to sell their chocolate in the United States because they're giving their money to a named bad actor that uses slaves to profit in their company. So, there are how many children that would be categorized as slaves in West Africa. But beyond that, there is forced labor. And beyond that, we have de facto slavery. So if we look right now at the world market cocoa price and consider that farmers in West Africa, let's say there are 3 million farmers in West Africa, they receive a fraction of that world market price and live right now on $1.25 a day. So if that farmer who's making $1.25 a day isn't a de facto slave, I don't know what is. And the answer to this is multifaceted. It's this litigation, it's other litigation, it's legislation, and it's awareness by consumers around the world who can understand that it's not only is it not fair, but it's not right. If once consumers, and they are gaining a greater understanding, once they understand what really goes into a chocolate bar, then they're going to be willing to pay a fair price for that chocolate bar. We aren't fair trade certified. I don't want to be fair trade certified. I don't believe in it. I'm not certified anything. I go myself and make sure there aren't child slaves harvesting cocoa beans that I buy. It's not that hard. It's not hard to do. And so for companies like Nestle and Berry and others to claim how difficult this is, or even to claim that they don't have knowledge by the use of subsidiary corporations and shell corporations is laughable. It's laughable. And they should not be able to skate away from corporate liability through the use of these subsidiary corporations and other corporations. And they can make money and still pay a fair price for those cocoa beans. Paying a lot more money for those cocoa beans would solve this problem right away. Thank you for having me here, Charity. I appreciate it.
Great. Thanks, Shawn. That was really helpful. I think that's also a great segue. So thinking about some of these moral, but also business arguments for why corporate liability is important. So Diana, who joined Joseph Stiglitz and another economics professor, Jeffrey Heel, in this amicus brief, talked a little bit about why corporate liability is an important incentive for companies. So from an economic or public policy perspective, Diana, maybe you can talk to us a little bit about why this is important for a functional economy.
Sure. Thank you so much, Charity. And Shawn, it's hard to follow you. That was fascinating. Thank you. So yeah, our brief dives into the economics of the Alien Tort Statute, as Charity mentioned, and it first sort of debunks the idea that it costs American companies painful amounts of money, or that it somehow harms the U.S. economy as a whole to have corporate liability. So yesterday, Justice Breyer mentioned that about 180 companies have been sued with the ATS over the course of the statute's existence. If those were all American companies, which they're not, that would create, we calculated a roughly 0.00002% chance of litigation for any company, which really dwarfs the likelihood of getting struck by lightning, for instance. So furthermore, defendants have not pointed out a single example of a company imploding or even being really hard hit by ATS litigation. So the idea that it's economically harmful for companies, we find to be very far-fetched. And so when we really drill down into the impact of corporate liability, what we see is that it actually boosts companies' long-term value. And so I sort of analogize corporate liability as vegetables for the private sector. In the short term, they're really not interested in it, but in the long term, it's very healthy for them and very beneficial financially. And so in practice, what we see is that more sophisticated companies are actually understanding that. And even defendant Nestle, Amicus Coca-Cola, and others are realizing this more and more. So corporate liability is incentivizing companies to strengthen their human rights due diligence process and engage in more responsible business conduct. The OECD recently released a study that was trying to quantify the benefits of responsible business conduct, and they showed that it correlates with an increased stock price and shareholder returns, improved reputation, brand value, better access to financing, lower operational costs, and really a wide variety of other associated benefits. And I would say chief among these, when we're looking into this, is the reputational boost that companies derive from stronger human rights performance. So companies use this to attract customers who are willing to pay more money to support companies that they perceive of as ethical, to attract investors who want to put their money in companies that they view of having a low risk of scandal or litigation. And it also really helps companies attract and retain talent. And this is particularly true among millennials. So I think we'll see these benefits continue to grow. And as I mentioned, defendant Nestle and Coca-Cola very clearly recognize the value of this, right? They have each dedicated significant amount of resources and portions of their website to publicize their human rights policies and practices. They're really trying to sell themselves to the general public as being very socially responsible. So it's apparent to me that they really understand the financial value of developing a reputation as a strong human rights performer. And something else too, sort of comparing the United States to other countries as well. So Justice Kagan noted in an oral argument, yesterday, that other countries that are home to wealthy multinational corporations are currently expanding avenues for civil liability for human rights abuses. So over the past few years, we've seen advancements in France, the Netherlands, United Kingdom, Canada, Germany, Italy, and a host of other states that are really ramping up civil liability. And increasingly, this is becoming the norm for countries that are home to multinational corporations. So unlike 20 years ago, when the United States could have been considered sort of a leader in civil liability, I think today we really need to try to strengthen the ETS and strengthen avenues for civil liability if we want to keep pace with our competitors in these foreign jurisdictions, so we don't sort of fall behind, and really try to take advantage of those reputational and financial benefits that we see over the long term that accrue to companies that are really strong with their human rights performance and practices.
That is super interesting, Diana. It's a really good kind of perspective. I think so often we think of sort of the economics professors as potentially being on the other side, but there really is a strong economics argument for corporate liability here. Before we go over to questions, there's a couple of really interesting things that I thought came out of the argument that I just wanted to mention here and see what comments or thoughts any of the panelists have on these. So one was something that Justice Alito said to Neil Katyal, which I just thought was fascinating because it shows Justice Alito, of all people, having, I would say, some understanding of greenwashing. So, and this kind of relates, I see in the comments we're having some discussion about fair trade versus fairly traded. And this is something that Shawn also just spoke about, kind of the idea of how effective is certification and a lot of the initiatives that corporations have invested so much in to clean their images. So what Alito says is, so suppose a US corporation makes a big show of supporting every cause du jour, but then surreptitiously hires agents in Africa to kidnap children and keep them in bondage on a plantation so that the corporation can buy cocoa or coffee or some other agricultural product at bargain prices. Justice Alito, ladies and gentlemen. So he said that the conclusion of that being that victims in a case like this, like if that happened and then victims in a case like this would be unable to bring a case where that corporation was based, he said that conclusion would be hard to take. So I thought that was really interesting. I'm kind of curious of the panelists, what do you all make of this? Does this mean that Justice Alito is actually super sophisticated on greenwashing and we can count on his vote? Or do you all see something else in this? I'm going to kick it to Terry first because I see him gesticulating. Terry, do you want to respond to that?
Have to unmute myself. Okay. Well, I think he made up for that by unfairly beating up Paul on an issue that wasn't before the court at all. But, I think that they all found it to just be an interesting intellectual exercise. And some of them believed what they said and others were just being tough on Katyal, and he deserved it. I wouldn't read any sympathetic vote by Alito into that at all.
If I could just add to that, I think that I agree with Terry. I mean, I'm not expecting Justice Alito's vote, but I think that it also signifies the point that I made at the beginning, really, which is even Justice Alito wants to step back from the broadest arguments that the corporations are making to gut the statute. And so he may not be sympathetic to the use of the Alien Tort Statute, and he certainly hasn't been over the years, but he may be willing to go along with other justices in allowing some scope of remedy under the Alien Tort Statute. And I think right now that's really what we're fighting for. We want to hold on to some ability to use the Alien Tort Statute to police US corporations when they engage in this kind of behavior, until Congress passes additional legislation, as they have in the Trafficking Victim Protection Act, and they may in other contexts. I mean, I don't think any of us are opposed to Congress acting more forcefully to go after corporations that violate human rights. They should, right? I mean, there's no using a 1789 statute for this purpose is less than ideal. But we use the tools that we have available to us to get at the problem. So until Congress acts, hopefully we still have this tool, to at least in egregious cases like this one.
If I could just add, Charity, one thing I think that the general consuming public doesn't understand about this litigation that's been going on for 15 years is that they have not had an opportunity to have their day in court. There hasn't been a trial. There hasn't been a jury. There's been zero evidence submitted by way of any fact finder looking at anything. And all they're asking for in all of this that we're talking about right now is just an opportunity to prove these things that we're talking about. So we talk about corporate liability, we talk about what's happened to these plaintiffs and whether or not aiding and abetting can be proven in this case, and did they know or should they have known and what standard? Nobody's written any jury instructions because they haven't had the chance to do that. At the very minimum, I mean, just give them a chance to have their day in court. And I mean, so I think many people find that shocking that there's been 15 years of litigation, but yet no trial, nothing.
It's a really good point, Shawn. That's part of why you're a perfect person to be on this panel, who's both a chocolate company like CEO and a former attorney. So I just want to raise one other issue before we go to questions, which is just, I'm sure a lot of people are thinking about Amy Coney Barrett. She's the newest justice. We're trying to kind of get a read on her. I think everyone had a lot of ideas about her going in, but she does have an opportunity to prove herself now. So based on the questions that she asked or the comments that she made, I'm curious if anyone has any thoughts on what this argument said about her.
Raise one point. So sometimes these cases get dealt with in this, we call it a two-step process. Step one that the court announced in SOSA is the question of whether or not there's a norm under international law that's sufficiently sort of universal and specific and well articulated that US courts are going to be able to adjudicate them. Then if you pass that step, you go to step two, which is this question of whether or not there are countervailing reasons. For example, would this infringe upon the separation of powers in the role of Congress, or would this complicate foreign relations? And one question that struck me that Coney Barrett asked was whether or not we should be looking at this case as a step two case. She's clearly very, very concerned about the idea of ruling that there is no norm against child slavery, child trafficking, forced labor in your supply chain, or aiding and abetting child slavery or these other acts. And that clearly she didn't want to go there. And so she was potentially looking for another way to potentially resolve this case by looking at these prudential concerns about separation of powers and foreign affairs. I think, the idea of particularly, a parent, with children, imagining writing an opinion that would immunize that kind of behavior, I think is difficult for all the justices to take. And I think Paul mentioned that we saw this real hesitancy, and even Alito saying that these are hard to take, right? The outcome is if we rule in the strongest way that the defendant corporations have asked would be very hard to take. And I don't think anyone wants their name associated with that. So seeing her, trying to avoid a ruling that would somehow undermine the strength of those prohibitions. And I thought Neil Katyal's answer was just stunning, where he said, well, okay, of course there's a norm against child slavery, but I'm not sure there's really an established norm against aiding and abetting child slavery. And I just think so many in the audience were, I'm sure, thinking like, why are you making that argument? Do your clients really want you making that argument? Do they really want to be associated with that argument? But he made it in open court, so that's his to live with.
If I could just add to that, I mean, one of the overall, I thought that that Coney Barrett's questions were very insightful, and where she really understood what was going. I mean, she's obviously a very smart person. The other add-on to what Beth said is that, unless I'm hallucinating and remembering this, which is very possible at this point, I thought she made a statement about SOSA Step 2 that virtually any argument about foreign relations would basically wipe out SOSA Step 1. I think she understood that just mouthing the argument that there's separation of powers or foreign affairs principles shouldn't be enough to undermine SOSA step one. And I thought that was, I mean, that's our perspective on it. And one thing we didn't mention, I think, at least I can't remember mentioning it, is that the government lawyer Gannon made a concession that there weren't any actual foreign policy issues in this case, which I thought was stunning, right? I mean, and Katyal said the same thing. So they're talking about hypothetical problems of some other case, and no one's identified a problem with this case, whether it's the Ivory Coast government, our government, any government. And so it's all just corporations blowing smoke. And I think Justice Barrett understood that at a fundamental level, which is really hopeful.
Great, thank you both. Very interesting comments. So I want to switch over to questions that we have about 18 minutes left. We'll try to hit some of these. I know there's been some interesting discussion in the chat. So for folks that actually have questions that you want to be addressed, please put them in the Q&A because I can't manage both as a facilitator here. So first question from Terry Fitzpatrick at Free the Slaves. Hi, Terry. He says, the Trafficking Victim Protection Act is up for renewal next Congress. Is there something that could or should be done on renewal to address liability of US corporations for forced labor and trafficking overseas?
Yes. The one thing, we were talking to Engel's staff about this before he lost his primary, but the one, other than some dream of expanding it beyond forced labor and trafficking to cover all of the other ATS norms, that would be nice. But a simple fix is that the definition of forced labor is not crystal clear in terms of its application to child labor and the relation. And that everyone seemed to think it was a good idea to clarify that forced labor includes children who are required to perform the worst forms of child labor under Convention 182. And the theory is that children cannot legally consent to work. So if you put them to work doing hazardous work, that should also be the equivalent of forced labor. That would be a simple fix. And in fact, I already have the language to do that if anyone is interested in receiving that.
Great, thank you, Terry. Let's just keep, oh, Beth, did you want to add on that?
Great, go on.
Okay. Tess Graham from Just Security says, Justice Thomas asked Paul yesterday about the possibility of bringing this case under other jurisdictional theories, such as diversity jurisdiction. Could you speak to the availability of diversity jurisdiction in this case and whether there would be a cause of action under 1332, and would international law provide a cause of action in diversity? That might be for Paul.
Yeah, and my recollection is when he first asked me that question, I was able to answer that there wasn't, because originally there was incomplete diversity, technically. At this point, now that all the foreign corporations are out, I mean, in a case like this, you could have diversity jurisdiction. Whether there would be a cause of action arising directly under the law of nations raises a whole host of gnarly jurisprudential questions that had, I mean, the status of customary international law within the US domestic legal system, and conservative commentators and others have fought about that. One thing that would be clear is that you could bring a tort action based on foreign law, based on the transitory tort doctrine. We received from the British the idea that torts follow tortfeasors. And so if a US corporation commits a tort somewhere else in the world, anybody that's been victimized by that can bring a tort action in the United States in US courts, be they state courts or federal courts. And in fact, in a couple of the other ATS cases where the federal claims have been dismissed, the ATS claims have been dismissed. In Doe versus Exxon, we're proceeding on torts in violation of Indonesian law. In Doe versus Chiquita, involving mass murder in the banana growing regions, and in Colombia, we're proceeding on claims based on Colombian law. And so there are other possibilities. You know, I read that question as part of the argument that, well, if you've got some other available remedy, you don't need the ATS, which I think ignores the fact that the ATS was designed by the founders as a statement that we would enforce international law. It's not just because it's the only remedy, it's because it is a remedy. And the fact that there might be some others shouldn't prevent us from being able to use it.
I would just add that while we're making out our Christmas list for Congress, we should think about expanding the Torture Victim Protection Act as well. I mean, this is a modern articulation of the idea of the Alien Tort Statute, that federal courts should be an appropriate forum to bring claims involving violations of the international law. And I think Paul is right. It is a little awkward to be using this old statute whose history is still being revealed now, even 200 years later. We're finding new, and Paul mentioned it in his remarks before the court, and we've got a big post on Just Security that talks about some of these new papers from Jefferson and others that really envisioned the ATS as a tool to enforce international law. We were doing our duty as a member of the international community to create a federal forum to do that. Congress did draft and enact the Torture Victim Protection Act more recently. It does not allow for jurisdiction over corporations, so that's an obvious place that we could imagine amending that statute. And there are plenty of limiting principles that you could put on that. So for example, looking at the Department of Labor, looking at US human rights reports, looking at the TIP report, the Trafficking in Persons reports, allowing for suits to be brought against corporations that are doing business in countries that clearly are not able to adhere to their international human rights obligations. And so this becomes an appropriate way to police that and to police the contribution that US corporations might be making to those abuses overseas. I could also see expanding the Torture Victim Protection Act to include other causes of action. Right now it supports causes of action for torture and for summary execution, but why not war crimes, genocide, other crimes against humanity? So that's another area where Congress, if it's serious about this, and serious about positioning the United States as being supportive of accountability for violations of international human rights, they should be thinking about expanding that, particularly if the court does end up truncating the Alien Tort Statute even more. It is true that I don't think it would gut the statute if they ruled in favor of no corporate liability, but it would do real damage. And it could do real damage if they rule that there's no aiding and abetting liability, because many of the cases involving natural persons, individual suing individual, they're not necessarily able to sue the direct perpetrator. They're suing someone that was somehow involved as a superior, as a co-conspirator, as an accomplice, because that's the person that happens to be here in the United States, and we can get personal jurisdiction over them. And so thinking about how to expand out this statutory framework to be as robust as the Trafficking Victim Protection Act, which includes civil liability, criminal liability, corporate liability, opportunities to have trade remedies so that goods that are produced by virtue of slave labor can't come into the United States, as was mentioned. We should have a broad-based human rights statutory framework that covers other human rights violations as well.
Charity, if I could just briefly add that it's an interesting campaign concept that I think we all need to start working on. Well, anyone who wants to help with the cause, if you will, that particularly yesterday, the company's lawyers, they were acting as if they repeated that they abhor child labor, but they acted as if they were intellectually offended because this statute doesn't quite fit the check the boxes that it would need to check, that they would otherwise support anything that's against child slavery, but this statute just doesn't work. It's not clear enough. We're not sure what Congress meant. So to call out the lie, to have a very specific proposal to pass a law that would clearly outlaw child slavery in any supply chain, and then to watch these guys figure out ways to oppose that we would be exposing that they'll oppose anything that would cause them to have to comply with a rule in their supply chains. And that's totally offensive. I would also quickly add that the Torture Victims Protection Act, I won a case in the 11th Circuit saying that it did apply to corporations. It uses the word individual, not person. And I think that was inadvertent anyways. And if we can't get Congress to even fix that, to change the word individual to person, then might as well forget any other dreams we have about reforming the law.
I would also like to add that currently, and I think this would be surprising to a lot of people, but Right now, the Food Safety Modernization Act, which went into effect 2 years ago, has a statutory framework that gives jurisdiction to the FDA on foreign soil to inspect programs called foreign supplier verification programs. Every single bit of food that's imported into the United States must be subject to a foreign supplier verification program and inspection and certification. So the mechanism is in place already in West Africa and all over the world to verify that products have not been made through slavery. Like, for example, right now, I had trouble last year importing avocado powder from Mexico because it was on a watch list. But yet, products made by slaves can come to the United States? What world are we living in? This is insane that an avocado powder can be stopped, and I couldn't get it for a month and had to fight with the FDA to get this, box of avocado powder in, but yet nobody is stopping any product at any border and saying, wait. I think slaves made this. We're going to stop this right here. That has to happen, and it can happen.
And sorry to prolong the point. Thank you, Shawn. Charity and Charity's organization and my organization and Paul also worked on it. We did file a petition under the Trade Act of 1930 to ban the importation of cocoa from Cote d'Ivoire for most of the companies that we are concerned with. We have been engaging with, it's been a while because the coronavirus has made it difficult. We've been engaging with the Customs and Border Protection people who at the investigatory level seemed sincere, but they sort of hemmed and hawed and winked and kind of conceded that their bosses weren't going to let this go anywhere. But that is another way to engage the Biden people when they have some new appointees in place, to remind them that this has been sitting there since February 14th, Valentine's Day, when we filed it, and that we ought to be getting some action on it, because no one denies that there's forced child labor in their cocoa supply chains, and that ought to be a prima facie, absolutely slam dunk case. And if we can't win that one, tear that statute up too. I mean, we've got to get some results from these laws that look good.
What about shareholder derivative actions? You would think that some of the shareholders listening to yesterday's oral argument would have been wincing at the thought of what was said in court.
That's a good point. I know some lawyers who do that work almost exclusively, and I think that's an excellent opportunity to ask them to do something on that.
I'm going to say we've got about 6 minutes left, and we have a lot of questions that we're not going to get to. So I'm just going to skip through a few of them quickly to see if we can get whatever answers out there we can. Aaron Andrews asked a great question about a place where people can share links to stories of the victims or child trafficking victims. That's something that we could probably, when we put the recording of this webinar on our website, we'll include a few of those links, and maybe Terry, maybe you have some stuff from Mickey Mastrati. I know Peter Wariski's coverage of this. He's had a few really great articles that had photos and stories, so we can try to aggregate some of those on the site.
And our petition has good evidence in it, that some of which is not confidential, that would be very helpful.
Yeah, our Section 307 petition.
If the questions could be sent to an email and circulated to us, we could respond after the webinar too. I'd be happy.
Yeah, that's a great idea. So for any questions we don't get to right now, we will we'll try to find a way to do some response. I think we have some record of people who participated. Maybe one other one we could get to, maybe we could get to two more. Borislav Petronov from OSF Human Rights Initiative says it's an amazing panel. Oral arguments yesterday were fascinating. And he says, justice is wonderful and justice is slow and often comes quite late. How do you see these cases in the context of the larger project of influencing decisively, ? Corporate behavior? Does anyone want to respond to that?
Well, I don't know, but I could start. Terry and I have been laboring in these fields for a long time. I think that I look at this in the longer term perspective. I think when we started doing alien tort statute cases, in the 1980s, I think we all understood that what we were trying to do is create a foundation for taking further steps and to get the courts to be open to hear these claims, to get the public to understand the reality of human rights violations that we were attacking. I think that project has been slowed by the conservative trends in the judiciary. But I don't think they're ending. I mean, I'm very optimistic that we have made a lot of progress, but it's just going to take time. And I think it's not just these kind of cases. It's the kind of work that Shawn's doing, that others are doing. And I think we should be optimistic about that. There are going to be a lot of different, it's not like these suits are not going to be filed. If they took away the Alien Tort Statute, we'd sue them under something else. I mean, I think the facts are just too strong. The need for reform is too strong. And I think we all just have to think of creative ways to use the tools that we have. So even if it takes a long time, I mean, in this case, it's taken a ridiculously long time. But the reason for that is that the courts keep throwing up obstacles, but we'll overcome them in time. I mean, it's a shame we can't overcome them all at once, but I don't think we should stop. I think we'll succeed.
If I could briefly add to that, thank you, Paul. Paul and I have admitted to each other that we probably are ill in some way because of our willingness to continue to believe in the cause. But idealism and just thinking positive, I mean, you have to, otherwise we would have quit long time ago. I'm taking a backup measure in that my son's a second-year law student, so when I die of old age, he can tag team me or something. But I would like to, it was so nice to meet you, Shawn. I think one of the things that we're really failing miserably at is harnessing consumer power. And when I tell one person face to face what Nestle does, they say, I'll never have a Nestle product again as long as I live. But communicating that to the masses so that people collectively say, we're going to not do that anymore until they stop using child slaves, it just hasn't worked yet. Maybe we need a whole lot more money for public relations, but that's something I hope we can all circle back on and think about, because while we're waiting for these decisions, we won't get a decision in this case till May or June. While we're waiting, we got to make these companies feel like even if they win, they're going to regret it. They're going to be famous for legalizing slavery. That should be something that we can do. Thank you.
Yeah, just one other quick thing that I should mention that our firm and with Terry and others have filed a series of consumer cases under the California unfair competition laws, basically arguing that the companies are making misrepresentations to the public about the fact that they're engaged in fair trade or sustainability, and we're making the argument that you can't say that to the public if you're using slavery created beans. And we actually have an argument on motions to dismiss next Friday in 3 of the cases. So the cases are going forward and new legal theories are being advanced, and I think in part because that they should be punished for their lies to the public.
Oh, go ahead.
I just sent to Paul today our draft TVPRA case that we're going to file against all of the big cocoa companies fairly soon to give them something to do while we're waiting for this decision as well.
And if I could just very, very quickly add in that I think, at least at Oxfam, we view the
Shoot. Is she frozen for everybody? Yeah. Okay, Diana, I'm sorry that you're frozen. I kind of want, there's one more question that I wanted to see if we could squeeze in. Can people stay over for 3 or 4 minutes? Okay, here's the last question. So Deborah Hensler writes, what did the panelists make of the justices' questions about whether simply acting as a corporation should distinguish the defendant's behavior from the behavior of a group of individuals not acting in corporate form? Was that just an intellectual exercise? I kind of wanted to ask that question myself. So if anyone wants to give a quick response to that.
I thought that was a very good question. I mean, I think that basically they're underscoring the incongruity, right? That it just makes no sense if 10 people get together and they can be sued, but if they incorporate, they get immunity. That just makes no sense. And so I thought that question was really helpful. It underscores the sort of the craven nature of the corporate liability argument that the corporations are making, really. That they should get, if an individual can be sued, but then if they incorporate in some way they can't be, that's just stupid. And
do you think that's going to hold any weight with the conservative justices?
Well, I think that since Citizens United, Citizens United gives corporations all these rights, and I think that this court has been reluctant now. I mean, in Kiobel and in Jessner, they were asked to give corporations immunity, and they stepped back from that. And I think one of the reasons that they do is that how can they say that corporations have all these rights, but when they incorporate, they don't have any responsibilities for the most serious human rights violations? It just makes no sense. And I think even the most conservative justices will look at that and say, well, we can't do that. What are the headlines going to be all around the country, you know, when they say, well, yeah, no, corporations can't be sued for engaging in child slavery? I mean, that just doesn't pass any kind of test.
Thanks, Paul. Beth, did you want to add something on this and be the final word? You're good. All right, we're a little bit over, so we should close out. There's so many really good questions that we didn't get to. We're so appreciative of all of the folks that decided to participate in this panel today. Our panelists were amazing. I'm sorry we seem to have just lost Diana Kearney for internet reasons. But this was really terrific, and I'm so appreciative, Shawn, Paul, Beth, Terry, and Diana, for the time that you put in. Your thoughtful answers to all of these questions. We're just so appreciative. So everyone watch the website. We're gonna put a link to this recording on the site, along with some other resources around the cocoa industry. Also check out Just Security blog. There's really good information there. Beth, do you want to plug that real quick before we?
Yep.
That's it.
It'll be
Okay, yeah,
ongoing
there's a
this
lot.
week, so we're covering a lot of these issues in greater depth. Please feel free to check it out. And Tess Graham is our ace editor on that one.
Okay, and we'll see if we can find a way to provide some answers to some of these other questions via email or possibly on the website. So we'll keep you all posted. Thanks so much.
Thank you. Thanks for the invitation.